My name is Marcus Fuller. I am a labor relations specialist on the Accountability and Workforce Relations team here at the U.S. Office of Personnel Management. It gives me great pleasure to welcome you to today's webcast training entitled Contract Administration Information Requests. Our office presents webcast training in support of our ongoing effort to bring relevant and reliable developmental opportunities to federal sector employee and labor relations practitioners. Our speaker will discuss rights and obligations regarding information requests under the Federal Sector Labor Management Relations Statute. If you have any questions about the training, you may send an email to awr@opm.gov. We will do our best to field as many questions as possible. Please note that your webcast instructions also included a SurveyMonkey hyperlink to an online evaluation form. Simply click the link, follow the instructions, and your valuable instant feedback will be sent to us. We are pleased to have as today's speaker, Frances Austin. Frances is currently serving as the Senior Labor and Employee Relations Advisor with the Department of Homeland Security in Washington, D.C. Frances has more than 20 years of human resources experience in the federal sector with service at 9 federal agencies. Please join me in welcoming Frances Austin.
Hi, and good afternoon. I'm here to speak on information requests, and I want to thank OPM for this well-constructed training presentation. During the course of today's presentation, you'll see the slides, and there are case citations on the slides, and there are also case citations that I'll be giving you. Total number of cases that we may or may not speak about today are 35. So there are a lot, we're going to give you a lot of information, and this is to prepare you because as the LR specialist, you have an important role, and much like a train engineer, you act like a conductor for the LR program. So the LR specialist keeps things running on time, dealing with unfair labor practice management, grievance management, information request management, and all the like that. So all of these things that you're dealing with on a day-to-day basis are time sensitive and require coordination sometimes with other parties and everything. So this is a really important skill that you are developing through your career, and something that is important for you to do is manage these things and make sure that everything runs on time, because you don't want to be responsible for losing an arbitration because a grievance response was not timely, or for losing an unfair labor practice complaint on an information request because the agency didn't properly respond in a timely manner. So we're going to start now with the basis. The statute, the Federal Service Labor Management Relations Statute, 5 U.S.C. 7114b4, provides that there is a part of the duty to bargain, the agency, upon request, has to provide data. Now, the data that we talk about that uses the word data in the law, generally that's just information. So when we say information request, we're talking about information. So we're not specifically looking for I's and O's in data, but what's on the slide is how it's spelled out in the law, that it's normally maintained, it's reasonably available, it's necessary for full and proper discussion and understanding of negotiable subjects, and it doesn't pertain to guidance, advice, counseling, training for management officials or supervisors related to collective bargaining. So all of these things we're going to get into a little bit more as we go through the presentation. So just things to remember, that if the union hasn't put forth a particularized need, then you need to leave the door open. Don't deny right off bat, but open the door and say, we need clarification as to your particularized need. If the information that they're requesting actually doesn't exist, go ahead and tell them that right away, because that's important that you go ahead and tell them, and we'll actually talk about a case that happened that comes from. And you have to timely respond, even if you're denying the request. So the FLRA case law demonstrates the expectation that the parties will discuss alternative forms of or means of disclosure that can satisfy the union's information, need for the information, and alternative forms or means that satisfy the agency's reasons for not providing the information as requested. So these are all things we're going to talk about as we move through the next hour. Again, if you have questions, you can email them to awr@opm. So in 1995, the authority in the case 50 FLRA 661 adopted the particularized need standard. Actually, that may not have been in that year. Anyway, but that's where we're really looking at. They've outlined particularized need in that case, which is cited several times today. And so we're going to talk a little bit about that. In that case, the authority said, we hold that in determining whether and how requested information must be disclosed under Section 7114B4 of the statute, we will consider both parties' interests consistent with the aforementioned judicial decisions construing Section 7114B4 of the statute and private sector labor law. Specifically, a union requesting information under that section must establish a particularized need for the information by articulating with specificity why it needs the requested information, including the uses to which the union will put the information and the connection between those uses and the union's representational responsibilities under the statute. The requirement that a union establish such need will not be satisfied merely by showing that a requested information is or would be relevant or useful to a union. Instead, a union must establish that the requested information is required in order for the union to adequately represent its members. So that's the key, and that comes from Justice v. FLRA, the circuit court decision, Fifth Circuit Court, 991 F.2D 285. So that's where they're talking about that, and that's where we get our particularized need. And a little bit about these three cases on the slide. So 50 FLRA 661 was, that was basically, it has to be, they said there was, they weren't really giving us the particularized need. So they chose this case. It was IRS in D.C. and Kansas City versus NTEU, and they chose this case to say we set forth the approach to determine whether the requested information is necessary within the meaning of Section 7114B4. And then we had 51 FLRA 1467. This was DOJ INS in Minnesota versus National Border Patrol Council. And they were requesting particularized, they were requesting sanitized discipline records. And in this case, it was established that they needed those records to properly represent employees. Then there is 64 FLRA 293. This was SSA and AFGE Council 215. They wanted lunch and break information from 139 offices for a period of just over 3 months because the agency was talking about having actually scheduled lunches and breaks. And so what the union has established a particularized need because they needed the factual information to respond to the agency's proposal. The ALJ initially said, well, that's not necessary, but he was reversed. So it's kind of interesting reading, and you know, one of the things that I like to do is read case law. Anybody who knows me knows that. So now a little bit more about particularized need, and this is to show that the requested information is necessary. The particularized need has to get into why the union needs the information, how they're going to use the information, and how that use of the information relates to their representational duties under the statute. And this also includes the scope of the request, because you know the union will come in the door and they'll ask for 10 years worth of records, and you know for nationwide, when really they're dealing with something that happened locally and has only local impact, and really they could deal with it for a 2-year period or whatever. So in establishing that particularized need, they have to also show the reason that they need it for the time period requested and the geographic scope of the request that they're asking for. So now the question is, how specific is specific? And this one so the first, second, and third bullet on this slide come from the one we talked about earlier, 50 FLRA 661. The last bullet is from 56 FLRA 156. So they have to come forward with more than just a conclusory assertion that they need the information. And it has to be sufficient to permit an agency to make a reasoned judgment, because there also may be countervailing anti-disclosure reasons on the agency's part. So they have to weigh what is the interest that's being expressed. So they have to have enough information. But the union doesn't really have to give up all of their information in order to get the information in return. So they don't have to reveal their strategy, or if they have a potential grievant, they don't have to reveal who that might be. It's not required that there be a grievance filed in order for the union to request information to examine a situation that is a part of their representational responsibility. So that, and they're not required to actually describe the exact nature of what they're alleging the misapplication or violation of the policy might be. So those are important keys. You don't want to nitpick an information request to death, but you do want to make sure that they've established that there is a representational need and a responsibility that that the information would assist the union in taking care of. Now, we talked a little, I hinted at the whole non-disclosure question. So what if the agency does have a countervailing non-disclosure interest? It's important that you explain this interest to the union early on. Now, you're the labor relations specialist, and oftentimes I've had it come into me, and I didn't realize there was an anti-disclosure interest in what the union was requesting until I went to the management and I asked them for it, and they said, whoa, we don't release this stuff to just anybody. And I said, okay, well, let's talk about that. Let me understand what is this anti-disclosure interest. And so then, knowing that, I have to explain to the union early on why we can't disclose this particular information. So the cases that you see on the slide, 56 FLRA 156, the Healthcare Financing Administration, they had a countervailing non-disclosure interest, and it was demonstrated in the whole thing. I don't have a whole lot more notes on this one, but 60 FLRA 91, this one was the one where they chose to wait to explain their non-disclosure interests until later into the process, and they were chastised because they did not explain their non-disclosure interests early on. So that's one of the key things, is find out about the information that they're requesting, and if management or somebody tells you that we have an anti-disclosure interest, then you have to explain that to the union. And you may come across times when there are Privacy Act implications to the information that they're requesting. You'll remember I said something about one of the cases earlier that they were requesting sanitized disciplinary documents. So one way to look at the Privacy Act issues are, can the information they are requesting be sanitized? But if it is information that is subject to the Privacy Act, it's a federal law. It prohibits agencies from disclosing personal information about federal employees without the employee's specific consent. So it can apply to a lot of different things, as long as it is a record within a system of records that's retrieved by using an individual's name or other personal identifier, which can be last four of their social, or an employee number that's assigned, any number of things that are personal identifiers that would make that system of record a Privacy Act system of record. But we're not going to delve too deeply into Privacy Act. We're going to talk a little bit more about it. So even if an employee has not consented to the release of the information, you can provide the information to the union if the Privacy Act doesn't bar its disclosure. So there are like routine use things, or then there's like an employee who is actually being represented by the union, who's shown that they are being represented by the union, then you can't assert a Privacy Act defense in that case, because the union has an exclusive representation responsibility with respect to that employee. And then if the disclosure would be required under the Freedom of Information Act, it's not going to be prohibited under the Privacy Act. So if you're making a Privacy Act defense, that really you're getting down into the clearly unwarranted invasion of privacy, and you want to make, if you make this showing and the union still wants the information, then what they have to do is identify a public interest under the Freedom of Information Act and show how the disclosure of that information will serve that public interest that they're saying. So you're weighing it now against, you have the Privacy Act consideration, but they're identifying some public interest. In the case of like disciplinary records or something like this, there's usually no public interest for a run-of-the-mill employee. But where you see this happening is if we have somebody who is really a high-level employee who does something and is disciplined by the agency, then we may get something where the Privacy Act is not going to outweigh the public interest in how the federal government holds employees accountable. So those are just a few of the things that you see with the Privacy Act. And so now more on particularized need. When you're determining, the first bullet on this, it comes from 51 FLRA 462, which this one was an interesting one because it comes down to, they were requesting unsanitized disciplinary records, and they wanted the disciplinary records of both employees in the bargaining unit and non-unit employees for 5 years. So the agency was justified in demanding an explanation of their particularized need, and they were not required to hand over what the union requested. Now, there is, in the second bullet on this slide, it talks about the 10th U.S. Circuit Court of Appeals determined that if a union establishes a particularized need for some but not all information it seeks, it's entitled to that information for which the need is established. Well, that's the 10th U.S. Circuit Court of Appeals, and the FLRA does not follow every Court of Appeals decision, in which, in this case, this is one in which that aspect of the 10th U.S. Circuit Court of Appeals case is not one that the FLRA follows. But let me tell you a little bit more about that case. So we're talking here about 60 FLRA 791. And this is Air Force Materiel Command at Kirtland versus AFG Local 2263. They were looking for particularized need because they were looking at 15 different merit promotion actions. They said, an audit approach doesn't really establish particularized need because that was where the union's first salvo was, we want to do perform a post-promotion audit. Okay, doesn't work. We want to ensure compliance with merit system principles and monitor contract compliance. Well, so these were all some of these conclusory statements, and they didn't really pass muster as far as establishing particularized need. But when it got to, so the 10th Circuit felt that in like 14 out of these 15 cases that particularized need was met. And they said, well, you should have given the information that was established for those 14, but the FLRA says that's not really necessary. Now, here's, and that's the aspect in which we're going to talk a little bit more, but what the FLRA also said, so their first reason was, well, you didn't establish particularized need for all the information that was requested. And so you may have established it for some, but not all, so we don't have to give you any. That's what the FLRA said. Then the second reason was, you didn't really establish particularized need. So what the authority said was, well, what the 10th Circuit said was the authority is incorrect in stating that where a union fails to establish its need for all the information requested, a respondent is not required to provide the requested information, even if the union has established a need for some of the information. So that is where we make the distinction here, saying the FLRA doesn't follow that because I think they really didn't like being chastised by the 10th Circuit. And the 10th Circuit actually sustained the FLRA's decision on this, even though they chastised them about this particular thing. So the bottom line here is, in practice, in my experience, and most of the times, the union will establish particularized need for maybe 5 things on a list of 10, and you're going back with clarification for those other 5 things. But while you're going back with clarification for those other 5 things, frequently you'll go ahead and provide the things that you already have and the particularized need was established. That's just in practice. In accordance with with FLRA law, you do not have to do it that way. You can hold off on all 10 items until everything has particularized need established. But that's where practice differs from the nature of the law, and that's where we don't follow the 10th U.S. Circuit Court of Appeals in this particular aspect because the FLRA says, no, they were wrong. So, hope that was fun. Now, and I'm going to go back to that slide because I want to tell a little story that has nothing to do with this slide, but it does have to do with going back and requesting particularized need and requesting things from the union in the course of processing an information request. So when I first got to Fort Bragg, I was relatively new in labor relations, and I got an information request in from the union that was like 5 pages long, and we had a contract term that said we would strive to provide requested information within 7 calendar days. So I took a look at this, and, little me, I said, well, this is crazy. One, I'm going to need more clarification, but two, I'm also going to need more time. So I'm going to go right back out to them and ask for an extension, which it says in the contract would be granted absent any, reason. So I write them back and request an extension, and I had the request maybe 2 days by the time they got my request for extension back. So then I get this scathing letter back to me that says that this vapid labor relations specialist who doesn't even take the time to analyze our information request comes back for an extension, without even waiting for the 7 days to elapse. Well, okay. So, I call my mother and I'm talking to her and I said, they called me vapid, Mom. And I was really upset by this. And my mother just laughed. She laughed at me, and then I realized, okay. And she said, look, honey, that just means they don't know you. So this is just another opportunity to say, in the field of labor relations, you are just a representative of the agency, and nothing that the union says should be necessarily taken personally. There are opportunities for them to get frustrated with you in everything you do. And just because they do get frustrated doesn't mean you need to worry about that. So they just don't know you. So moving on. So here we have the stating that the records are, here we go, needed to allow the union to audit management actions or monitor contract compliance. Remember, we talked about these were reasons that they gave in that case, but it's not sufficient. You can go back and request clarification. And if you do go back and request clarification and the union doesn't supply clarification, then the union runs the risk of not having established that particularized need. So this is where you open the door for them rather than closing the door. Because if you close the door by saying you didn't establish particularized need and we're denying it. So go ahead and open the door. In this particular case, 51 FLRA 1391, they wanted appraisals about an appraisal grievance and everything. And the agency went back and legitimately asked for clarification about what they were looking for. And the union didn't respond, and they lost the case in the end. The union did. So, and so that's a key strategy here, is make sure that when that information request comes in, you're analyzing it right away. If you need clarification, you're going back to them with a request for clarification. And you're not looking at audit approach or anything like that, but if the temporal scope that they're requesting is absurd, you can make a suggestion to limit the temporal scope or something like that. So in this one, this is National Border Patrol Council. I mentioned this earlier. The particularized need for sanitized disciplinary records and adverse action records was established by stating that the records were needed to properly represent an employee in order to respond to allegations set forth in a proposed notice of removal. So this is where they were successful in establishing particularized need, and it was provided to them in the end. Now, moving on to the requirement that data be reasonably available. Data, information, So what this reasonably available means is that it excludes data that's available only through extreme or excessive means. It's a dictionary definition, and the case law here has, so 36 FLRA 943 is the case, and it was HHS, Social Security Administration, and AFGE Local 3302. So they just established this as a requirement, and basically what they did was they looked at Webster's 9th New Collegiate Dictionary and said, you know, in order to talk about this, we're just going to look at what is a definition of reasonably available. And they said reasonable equals not extreme or excessive, and that's the dictionary definition. So then the second bullet is really, that's from the case saying the agency had superior knowledge regarding to the costs and burdens, and so the agency has the burden to prove that that the data is not reasonably available. But in every case, determining whether extreme or excessive means are required requires a case-by-case analysis of all the relevant facts and circumstances. So this is just something that you need to understand what the bellwether is on this, and be looking at what is going to be required in your particular case to produce the information that's requested. And then if you have this defense that it's not reasonably available. In today's world, this is probably growing fewer and fewer times that we could come up with something like this. But, and then we're going to talk a little bit more about more cases. So information which required 150 staff hours of effort to compile at the cost of approximately $1,500 was reasonably available. And this is 37 FLRA 987. So this one is actually going back a little ways, but so $1,500 was worth a little bit more back then than now, but still. This was talking about TDY assignments that were given to military versus civilian employees. And this was Air Force Logistics Command at McClellan Air Force Base and AFGE Local 1857. And so management came up with saying, look, we're not going to give this information out because it goes to assignment of work, it goes to the Privacy Act in terms of these military personnel. But in the end, what they determined was, one, that this was reasonably available, even though they would have to go out and find this information in different form, and that it was relevant to the case because the claim was that they had an agreement about how civilians would be assigned TDY, and now TDY assignments were being shunted to military personnel. And so they were saying, look, you're not following the contract in assigning our civilians the TDY assignments that they're supposed to be getting. So that's how they wound up getting the information on military assigned TDYs. And that just keep your eyes open about what they're asking. Normally, we wouldn't give out information about non-unit personnel. So military personnel are not part of a civilian bargaining unit. However, in this case, it was determined that they should be given out. Now, information that consisted of 10,000 or more documents of 11 Border Patrol agents for a 12-month period were considered reasonably available. This one comes from 40 FLRA 792. And this was DOJ INS, El Paso, Texas, and the National Border Patrol Council, and it pretty much is summed up in that bullet. Information that consisted of 5,000 to 6,000 documents, forms, reports, memoranda prepared by Border Patrol agents in various locations throughout the United States was not reasonably available as a matter of law. Now, this sounds like a contradiction compared to the one directly above, but when you look at the case, what these were actually was talking about was specific things prepared by individual Border Patrol agents on anything they touched, not something that management controlled the information, but they'll do a report on a vehicle that they cleared through a checkpoint. And so there was really no way to track these things, so that when you look at that and you analyze what it was that the union was requesting, and you consider what it would have taken, I mean, it really wasn't feasible to even get it. So that makes it not reasonably available as a matter of law. So in that case, that actually came down in the Fifth Circuit Court of Appeals in 991 F.2D 285, which I think I cited earlier. But So that's an interesting one that helps you understand how you can say something is not reasonably available. And now, normally maintained. This one, I recommend you read it just because it's fun to read, because when I read these things, I kind of imagine the management that's saying these things. So this one, 37 FLRA 1277, somebody at an award ceremony was granted an award, and the guy said, "You can keep your award, I'll just take the money." And the manager, I think, really took umbrage at this. So he gets mad. So after the award ceremony, he goes to some other managers and he says, "I want a memo about what you heard in that award ceremony." So he gets a memo from these guys. He puts it in his little drop file. So I have a memory joggers about this employee's refusal of the award. So months go by, and in the intervening months, the guy actually sends the check, which has been cut, back to the Treasury, destroys it and sends it back to the Treasury. The guy says, "Well, I never got my money about this award," and comes back about it. And he says, "But you refused the award." And the union made an information request asking about these memory joggers because, they have their sources of information, and they kind of knew that somebody had written some memos somewhere. And so in this case, what happened, management kept saying, "Well, there's no information about this. It's not a decision I made. It's a decision that the employee made when they refused the award." So the management lost. And they said, "Look, these memory joggers are information, and if you possess it and you have or you maintain the information," so in fact he collected these things from other managers and put them in a drop file, and he knew they were there. So you have to give it to them, and that was this case. So that's an interesting one, and it's not that long. So it's recommended reading from Francis. Now, in terms of... Did I skip one? Nope, that was it. Okay, there we go. Now we're returning to timeliness. The first bullet, the authority has held that information must be furnished in a timely manner to effectuate the policies and purposes and policies of the statute. It's holding in 11 FLRA 639, and the second one talks about is actually from 60 FLRA 674, talking about its holding in 45 FLRA 1022, which is the one cited on the slide. But so talking about those, well, 11 FLRA, there was a 2-month delay. This was, of course, back a long time ago because you're talking 11. I didn't get the year on this, but the information must be provided in a timely manner. But what happened was they were conducting a diligent search, and they did provide the information when it was received. So this was a 2-month delay, and it was not considered a ULP. Then we get to 60 FLRA 674, and that one... The union requested, so they were talking about something about the environs around the office, and the union requested security measures and crime assessments, saying they were looking at whether degree of compliance with the CBA on physical protection and building security. They requested this in a February request and an August request, and the agency never responded. So it's really important that the agency respond. That's one of your responsibilities as a labor relations specialist. And in my experience, there have been times where labor relations didn't get the information request. So you need to talk to your managers and make sure that if they get an information request directly from the union, that they are in fact forwarding it to you so that you have that and can track that and can ensure that it's timely reviewed and responded to. But in this case, they didn't respond, and they said a timely reply is necessary. And then we have 45 FLRA 1022, which, this one was an interesting one, DOJ Office of Justice Programs and AFSCME Local 2830. The agency withheld the information requested for a Privacy Act waiver. The union said it wasn't needed, and it really wasn't needed, but they didn't release the information until the Privacy Act waiver came through, and then they lost on that aspect in terms of the ULP. So that was a 5-month delay that was considered unreasonable because they didn't need a Privacy Act waiver. So And the final thing that I want to say on this is that it's really important. Oh, let's see. Then there was another case, 43 FLRA 1362. This was a 9-month delay. And this one, there was, the agency withheld saying, well, there wasn't any disparate treatment. And it's not up to the agency to determine whether there's disparate treatment. You don't withhold for that reason. And they kept withholding, and they had a 9-month delay. So that violated the statute. One of the things that you really need to know is don't destroy information that's under dispute. So even if the information comes up against its retention standard, you can't cut it off because it's still under dispute. And until that dispute is resolved, you're going to be found liable for that if you should destroy the information. Now, you may find situations where the agencies have to create documents that didn't exist if the information is available to you in an electronic format or something like that. So 37 FLRA 987, that is, okay, we talked about that one. That was the TDY assignments given to military and civilians. So they had all of those things in their electronic format. They just had to do an extract from the database and format it in some way to provide it to the union. And nothing in the language of the statute says that Congress intended that a union's right to information be dependent on whether the information is reasonably available from an alternate source. This is actually a negotiability case, 39 FLRA 1087, and Proposal 5 on this was that the union would be able to get the information, and management said, well, you can always get that from the employee. And it's like, no, it doesn't require that the union be able to get it from an alternate source. The agency should be doing this. And then finally, we had 2 cases on the standard that an agency can't charge a fee for copying information on records. And so when a union, so just kind of wrapping up here, we've talked about most of these things. When a union asks for information that doesn't exist, you're obligated to tell them that the information doesn't exist. 26 FLRA 324, there was some hint about a new smoking policy. There wasn't any new smoking policy. And so when the union asked for the new smoking policy, the agency didn't respond and didn't send a new smoking policy, but they also didn't tell the union that there was no new smoking policy. So they got slapped for that. And the agency must actually give the information to the union. It's not enough to allow them to review the information. And this is all about a crediting plan issue. So when we know that crediting plans are real sensitive, 42 FLRA 1002 was a case where they allowed them to review it, but the authority said it wasn't enough for them to be able to review it. They had to give it to them. Now, crediting plans are really on a case-by-case basis, and there's several cases about crediting plans. There was one in which the FLRA upheld an AJ's decision that affirmed an agency's refusal to provide the union a crediting plan. That was 64 FLRA 106, and it really turned on the particularized need, that the union didn't establish particularized need. So these are ones that you have to be really careful about because your staffers are going to say, no way, we're not releasing the crediting plan. You may have to, it just depends. So let's see. Certain information in an inspector general report may have to be disclosed. This is 24 FLRA 154. And then we have the memory joggers case that I talked about the refusal of an award. So information requests for memory joggers. It doesn't have to be a formal agency record, in which case, if they've got it, if it's somebody's calendar that says that they attended such and such a meeting and they took a few notes on that, that could potentially be something that is required to be disclosed in an information request. We just don't know until we look at it. And finally, the statute doesn't exempt from disclosure guidance, advice, or counsel to management officials concerning conditions of employment when those are not related to collective bargaining. I know that a lot of times people read that and they don't read the final clause in that exemption. So in this particular case, 41 FLRA 137, they had distributed guidance to management saying management guidance all about disciplinary procedures and actions. And this is not information that was related to collective bargaining. It was about personnel policies and practices. So that was important that they actually were found to have violated the statute when they didn't give it to them. So And as I mentioned earlier in my Fort Bragg example, if you have something in your contract that talks about information requests, anything that you've negotiated in your collective bargaining agreement, then that actually, they don't have to provide particularized need for that. So when you're negotiating, you want to be careful about what you give up in those sort of things. If it's standard information that you want the union to have on a regular basis, no problem. If it's something that you feel like, no, they should establish particularized need on a case-by-case basis, don't put it in the contract, because you're not going to be able to ask them to provide particularized need if it is already negotiated in your contract. And the FLRA webpage is a wonderful resource. You should go out there and take a look. It's this one that's showing, right, this is the guides and manuals page. They have training resources, and they provide a lot of case law on particularized need, and more discussion about Privacy Act considerations. But if you get a Privacy Act thing, then you want to talk with your Privacy Act people also. So the FLRA General Counsel's unfair labor practice case law outline also covers other issues about information requests, and it's a great resource. Also, the link on the slide here to get to that. And with that, are there any questions?
Yes, we have 2 questions from the web.
Okay.
The first question is, if a grievance time frame has passed untimely, and that's the reason given for why the requested information is needed, can we deny that request?
If the grievance time frame has passed and they didn't file a grievance, and they gave the reason that they thought it was a grievable action, I wouldn't say that you were safe to deny the information request on that. Because of that known or should have known thing, so they could successfully come back and say, well, we didn't know because the agency didn't provide us the information. And an information request is separate from a grievance and should always be looked at and responded to appropriately.
And this is the last question. Can you please suggest good contract language for our CBA regarding information requests? Our union always makes duplicative requests and routinely claims that we do not provide them with the requested information. They often use these information requests to stall for time before responding to charge discipline, and we would like to put in language in our CBA to deter this behavior.
I am actually not going to do that on the fly. I think that if you send that question to AWR, we will put some consideration into that and see what we can do with that.
Thank you, Francis, for sharing your expertise during today's webcast training. Your presentation has provided an outstanding and valuable overview of management's rights and responsibilities regarding information requests under the statute. I thank OPM's communication staff for your transmission of today's training, and thanks to the AWR team for coordinating this event. And thank you for joining us on today. We look forward to having you at the next Employee and Labor Relations training. Finally, please remember to fill out the online evaluation form courtesy of SurveyMonkey.com. Your feedback helps us to plan future webcast trainings, and we appreciate your taking time to complete the survey. Have a good afternoon.